Good afternoon and welcome. My name is Nilanjan Sarkar and I'm Deputy Director of the South Asia Centre here at the London School of Economics. A very warm welcome to all of you this afternoon when we are going to discuss a very, very important topic that is very contemporary. And I'm very happy to say that we have a fantastic panel to discuss this with us. The event this afternoon, as you would know, is titled Internet Piety, Blasphemy in Pakistan Today. We decided to do this event because there has been an increase in the number of accusations of blasphemy in Pakistan over the recent past, and one arena of surveillance has been social media and the perceived transgression of legality in social media posts, etc., etc. Central to this is, of course, the Prevention of Electronic Crimes Act, that's PICA 2016, which intersects with other laws to lead to such accusations of blasphemy. And therefore, it is also a very, very interesting legal question to explore. As I said, we have a panel of experts whom I'll introduce shortly. But before that, a very warm welcome to all of you who've joined us from different parts of Britain, different parts of the world, from different time zones. I know because I can see so many of you who have logged in just now. A very, very warm welcome to all of you. Thank you for joining. The event is happening via Zoom and is being live streamed on YouTube. And the chat function, as you will notice, is enabled in YouTube. Please ask questions if you would like to. You are welcome to ask questions to an individual panelist or speaker. You are equally welcome to ask questions to the entire panel, which I will then read out at irregular intervals and ask them to answer. Please bear in mind that questions have to be relevant to what is being discussed this afternoon. Now, had this event been happening at LSE, members of the audience at LSE have the freedom to not reveal their identities while asking questions. And in keeping close to that spirit, at least, I will not be reading out the names of those who are asking questions in the chat box. I'll simply read out the questions and I'll read the questions verbatim. I won't paraphrase them so that the panelists get to hear what exactly you are asking. It is now my very pleasant duty to introduce the panelists this afternoon. We've had a brief chat before we came live on air to discuss who would speak in what order, and the order in which I introduce the panelists is the order in which they will speak this afternoon. Dr. Afiya Shehrbano Zia is an independent researcher and author of Faith and Feminism in Pakistan, Religious Agency or Secular Autonomy, which was published in 2017. Afiya also recently published a blog on the South Asia at LSE blog, which is very closely related to the topic that is being discussed today, which you may want to read later on. Hadi Ali Chattha is an advocate and human rights lawyer and has represented several citizens of Pakistan accused of blasphemy. Farieha Aziz is co-founder and director of Bolo, a digital rights and civil liberties group based in Karachi in Pakistan. Our discussant this afternoon is Hassan A Niazi, who is an advocate in the High Court of Lahore and focuses on internet and technology law, amongst various other things. Everyone, welcome to this afternoon's event. Afiya, please speak first. You have about 10 minutes.
Thank you so much, Nilanjan. Thank you for organizing this as well. I will open by placing Pakistan's blasphemy laws in their historical arc, just to show how dramatically the meaning, the users, and the political work of these laws have changed over time. Yes, the laws begin in the colonial period. Section 295 in 1860 and 295A in 1927 were introduced by the British colonial rulers in India to manage communal tensions, not to guard theology. These were public order clauses, and colonial courts at the time insisted on intent, on mens rea, and evidentiary standards, as Osama Siddique and Zara Hayat have shown. But in post-colonial Pakistan, especially in the 1980s, these clauses are transformed through political Islamization, through clerical opportunism, and today, as you say, a fully digitized piety economy. So I'm going to sketch 4 key shifts very quickly to explain these. The first is the post-colonial mutation, where blasphemy law now becomes doctrine. Now, although we call them blasphemy laws, it's important to note that the word blasphemy never appears in the statutes, nor do terms like Tohine Risalat, which is insult to the prophethood. Because unlike the Hudud laws, these clauses are barely rooted in classical Islamic jurisprudence. However, between 1982 and 1986, under General Ziaul Haq, Pakistan expands the entire range, 295 to 298, upgrading these offenses to quasi-sacred decrees. And crucially, in 1991, the Shariat Appellate Bench, not a military dictator, made the death penalty mandatory for 295C, which is insult to the Prophet. So we see judicial Islamization becomes central, and the clauses stop functioning as public order tools. They instead become identity tests, markers of moral injury and pious belonging, as Farad Haq has shown. Now, the law also undergoes a conceptual shift. By claiming to guard the honor of divine personalities and sacred texts, these clauses effectively turn holy figures into legal subjects themselves. And as Asad Ali Ahmed has argued, this empowers the previously marginal and discredited Maulvi, giving clerical classes unprecedented moral authority now. Then the second shift, which is about changing targets. Up until the 2000s, most accused were religious minorities and the declared heretic Ahmadis. And also judges and lawyers who were defending them were often threatened or even murdered, producing a chilling effect inside courts. But from the 2000s, mid-2000s, we see a sharp rise in Muslim-on-Muslim accusations. For example, in 2004, the case of the singer-turned-Muslim preacher Junaid Jamshed, where he apologizes for having committed alleged blasphemy and was forgiven, which now showed how clerical networks have started applying selective mercy. But today, the data is clear. Most of the accused are now Muslims, and as majority communities police one another, over 3,000 cases reported since 1986, 344 cases just last year, and many more this year. Digital accusations now replace written complaints, and over 100 reported extrajudicial killings, including custodial murders. This is no longer a minority issue, it's a majoritarian piety economy. Also, coercion within the legal profession has expanded. Pietist lawyers groups openly campaign now to deny representation to any accused, even in obvious cases of manipulation. And meanwhile, the scale of violence has intensified. So in Gojra and Kharia in 2009, we saw the Sunni sectarian outfit, the Sipah Sahaba, leading large mobs to burn down Christian homes and churches over false claims of Quranic desecration. Similarly, a similar case in Jarawala in 2023. And also, a new figure becomes venerated, which is the sacrificial Ghazi who kills the accused. Shrines are now built for these men. Lynch mobs are taking triumphant selfies of themselves at murder scenes. And so these killings are not about just personal vendetta or spontaneous. They are collective performances in the name of faith. And then the third shift I date to 2015, where we see the convergence of political piety populism with the rise of the Tehreek-e-Labbaik Pakistan, the TLP, as a political party, and which centers its entire agenda around sacralizing the blasphemy laws, and Imran Khan's Pakistan Tehreek-e-Insaf Party at its populist peak, invoking an undefined revivalist Riyasat-e-Madina or 7th century Islamic governance. Both these movements' parties are Punjab-based, Punjab-led, and Punjab province accounts for nearly 80% of all blasphemy cases. Now, of course, long before this period, the laws were already weaponized for dispossession, land grabs, evictions of minorities, seizures of graveyards, and especially evacuee trust property. But with Tehreek-e-Labbaik's street power, blasphemy becomes the mechanism of hyper-local moral policing. So, a performance of piety. You have mosque committees, traders, teachers, young men monitoring speech, signage, calligraphy, TikTok feeds, children's textbooks, women's clothing and movement. And here the resemblance to RSS surveillance in India is quite striking. But the point is, at this point, moral injury becomes not just a claim, but political currency. And the fourth shift you mentioned also, Nilanjan, after the Pakistan Electronic Crimes Act in 2016, PICA, which expands the sites and definition of what can count as blasphemy. So now offense isn't just through speech or text, it expands to things like emojis, stylized calligraphy on women's clothing, perfumes named 295C, online gaming banter, TikTok aesthetics, videos of women near mosques, and even silence, for example, not adding the salutation after mentioning a sacred figure. And Farieha will talk us through about Pika, but just to note that in the digital landscape, a new subset of targets emerges, like secular bloggers, influencers, women debating polygamy, young men arguing with clerics on Facebook. So at this point, as you said, piety becomes surveillance capital. So these are the four shifts. Law becomes divine decree, targets shift, there's a rise of piety populism which strengthens blasphemy politics, and the digital landscape expands the scope of offense and it enables new actors like online piety peddlers and influencers. And just to add a quick note on class and gender here, historically, blasphemy politics hasn't just targeted the weaker classes. Elites have been accused and even assassinated. But the new entrapment model that we discussed today is more pragmatic and predatory because it targets lower middle and middle class young men who are digitally reachable, they are financially squeezable, and they are socially unprotected. And women whose digital presence, their clothing, aesthetics become prime sites for policing piety. So we have this combination of sexualized shame for both genders fused with religious intimidation. And underneath all of this is an emotional substrate because blasphemy endures not just as a law or weapon, but because piety, taqwa, haya, modesty, these are the affective glues that bond the stickiness of blasphemy offenses in Pakistan. And it's a glue that is so powerful that today it binds Bangladeshi and Pakistani right-wing actors pledging together to the blasphemy laws far more effectively than any pro-democracy coalition has managed in the past. And so it's against this backdrop that the Blasphemy Business Group or Syndicate emerges, where between 2021 and 2025, Pakistan sees the rise of its most organized blasphemy entrapment network. This group used AI-generated religious pornography, honey traps, doctored screenshots, and fake female accounts to trigger more than 700 FIRs or first information reports, multiple death sentences, custodial killings, and dozens of arrests. And so a special branch report and quite a courageous National Commission on Human Rights investigation uncovered a collusion between rogue Federal Investigation Authority officials, clerics, prosecutors, and moral entrepreneur lawyers like Rao Abdul Rahim. And what emerges is a decentralized extortion economy, which is built on manufactured and sometimes sincerely felt pious injury, but which has no evidentiary boundary. Only recently, thanks to a handful of very brave human rights lawyers and journalists, have we seen any acquittals or bail. But for the longest period, we were suspended in what seemed to be a case of no hope and just sort of expanding beyond control. So I'll pause here, Nilanjan, so the other panelists can detail the case itself now.
Sure. Thank you very much, Afiya. We're just as I speak with you, we're just going to paste the link to your blog in our chat box so that people can actually look at some of the details if they'd like to, also because there are some specific cases mentioned over there. In the meantime, our next speaker is Hadi Ali Chattha, who is an advocate and human rights lawyer and has represented several citizens of Pakistan accused of blasphemy. Hadi, please speak now. You have about 6 to 8 minutes.
Sorry, I had just some difficulty with my mic. Thank you so much for arranging this. and it's great to see that this is being discussed. I do not consider myself as thorough read and knowledgeable on the history of the law, how it came into its existence today as Afiya, but I've had the I've had the opportunity to defend most of the victims that were honey trapped by a gang called the Blasphemy business gang in Pakistan. Now, this is a new phenomena. What we've seen in Pakistan before was that people, for their personal vendetta or a personal grudge with any other person, if there was a land dispute, if there was a dispute over a certain relationship, if there was a certain issue or adversary through which you wanted them to be persecuted through a law, and this is a very serious persecution because the only option, legal option, the courts have here is death penalty in these cases. So that was a real threat and a real tool, a law that could be used to persecute your adversaries, your opponents. That had been happening in Pakistan for quite some time. But what we've seen with this gang is that a gang emerged in Pakistan back in 2022. They were operating before that as well. They've been operating since 2020. But before forming a gang, what they would do is they were taking vengeances from personal people, individual people they had issues with. But what they did in 2022 is that they formed an official gang, and they've actually named it. They call themselves the Legal Commission on Blasphemy Pakistan, LCBP. It was legally headed by a person, a lawyer called Rao Abdur Rahim. It had a collection of different individuals across Pakistan. There were people, most of them were for radical religious organizations like the Tehreek-e-Labbaik Pakistan, but there were also private individuals who believed that this was a very lucrative business and this was a way of making not just money, but also to climb the social stairs within their ranks where they were known for their religious radicalism. So what they did was they formed a gang, and the gang just threw a very wide net across the social space in Pakistan, social media platforms. And what they did was they realized that there are groups, um, some of the groups in on social space were sharing pornographic images and pornographic material, and a lot of these groups had members from Pakistan who had joined these groups. So what they did was they realized that this is very lucrative. What we can do is now we can throw a net on these groups and we can trap these young individuals who are probably by prima facie seems like they were in the groups for consuming pornographic material. But what they did was they got themselves added into the groups. So they added into themselves into the group and they posed as female members of the group. And from that group, they communicated with these young Pakistani individuals and told them that posed themselves as a female Pakistani citizen. And because they had a prima facie relationship with these other members as a female member of the group also consuming or interested in pornographic material. So they personally contacted them and asked them that we also, are we like to consume this pornographic material. And after that, they would ask them for there were few other modus operandi that were operating. They would either these female members would either ask them if they want a job in Spain or other foreign countries, and these female members claimed that they could get them settle down in these foreign countries. Or they would either say they can get them a job in Pakistan. Some of the female members would also tell these individuals that they would like to go on a romantic date with them. But whatever the modus operandi would be, it was just to lure them into coming into the trap. And they would call them to these restaurants or these cafes. And once the victim arrives there, he would not see a female member waiting for them. They would see five, six individuals who were member of the gang. Some of them I can name are Shiraz Faruqi, Shazad Khan, Ghazanfar Abbasi, Asim Mughal, Rao Abdur Rahim. From there, the victim would get kidnapped and would be taken to a private torture cell where he's tortured sometimes for a day or maximum to 3 days, where they're badly tortured. Their phone is taken away by the gang members, and blasphemous material is planted in their phone. Once it's planted, they were handed over to FIA, and FIA which has now been converted into NCCIA, was complacent in this, and they would ask these victims that we want you to give us around 8 million rupees or 9 million rupees if you want to get out of this. Otherwise, we will prosecute you for a case of 295C, which is blasphemy, which is Gustaki Rasul, disrespect to the Holy Prophet. And there is no way you can get out of it because they planted this material on your phone. So they've been doing that since 2022 to the point that it reached a total number of 750 individuals across Pakistan. They had made their own, circles and their own cells in different cities, including Karachi, Lahore, Multan, Islamabad, Rawalpindi, and Peshawar. So when the number reached 750, and these families realized that this is the same story with all of our children, so it can't be true. It can't be such a coincidence that all of our kids have done the same thing. And most of the parents then realized and knew that our kid was called or lured in by a woman for a romantic date or for a job offer or to settle them in a foreign country. So that's when they reached out to lawyers, and we were very. It was really helpful that they reached out to us and then gave us all our testimonies. After which we reached out to Islamabad High Court, and a writ petition for the constitution of a commission of inquiries to just investigate into this matter, whether these individuals have really committed blasphemy or not, whether their claim of being honey trapped is accurate or not. And when those hearings came on to be, 42 hearings took place and they were live broadcasted. So those hearings took out everything. There were evidences of evidence tampering. There was clear evidence of torture. There were evidence of being kidnapped. And then there were conversations with these female members of the gang who had honey trapped these individuals. And that led to the Islamabad High Court giving an order that a commission has to be formed by the federal government to investigate into the matter. But what's important here is that the federal government, the role the government of Pakistan has played in this matter is really shameful. What this government has done has, political parties who are in power right now have realized that the religious vote they can get from these individuals, the religious vote that they would not be getting if they form a commission of inquiries and put these people behind bars because what they've done is purely criminal. It's what you call is an organized gang, an organized crime being happening in Pakistan, which took 750 people in to incarceration in Adiala jail and other jails across Pakistan. And they have done nothing of the sort to help these people out. To this day now, because of the live hearings and because of lawyers like Iman and me and Talha, Sarfraz, Asif Tamboli, Usman Wright, these people, what we've been able to do through this is that we've taken out 102 total individuals out of jail from this gangs in trapped cases, false cases. But there's still a huge number of people who are still in there. And the gang is still operating in the sense that they're not able to get new FIRs registered. But what they're still doing is they're coming to court and they're trying to harass these people. They're threatening lawyers. They're even threatening judges if they're now giving bails or acquitting these people out of these cases because there's no legal basis in these files. Thank you.
Thank you very much, Hadi. Just one point of clarification. You said they are coming to court and threatening. Who are they threatening?
So what they're doing is they come to court and their way of appearing in court is they bring in a mob with them. So a single lawyer won't appear. He'll come in with 8 to 10 people. Most of them are not even lawyers or associated with the case. And what they'll do is sometimes they raise slogans inside the courtroom. And these slogans, which are normally "Gustakh ka stan sar se juda," and these sort of slogans, which are actually threats of violence. So the judges, especially in district court, are really afraid of giving judgments in favor of these individuals.
Yeah, sure. Thanks. No, I just asked it just so that members of the audience were clear about what exactly you were referring to. Our next speaker is Farieha Aziz. Farieha is co-founder and director of Bolo, which is a digital rights and civil liberties group in Karachi in Pakistan. Farieha, please speak now. You have 6 to 8 minutes.
Thank you, Nilanjan. Just to build on what Hadi has said, and just to make the quick connection, Afia mentioned the Prevention of Electronic Crimes Act. Now, the law, which was introduced in 2016, continues to be and was then a very controversial piece of legislation. It was hotly contested, and it was called and continues to be called a draconian piece of law, brought to muzzle dissent. However, the law itself does not carry a provision like the Pakistan Penal Code, offenses against religion. There was an attempt to copy that chapter from the Penal Code and introduce it into PICA. However, that did not happen. But what we did see is that those provisions in the PPC 295C and a bunch of others, and then together with Section 11 of PICA, which is hate speech, which pertains to sectarian, interfaith, or ethnic hatred, has been used together with this in FIRs, with first information reports. And what this then does is, because PICA is a special law and it has to be prosecuted in special courts, and it is only the FIA formally, which is a Federal Investigation Agency, and now after the amendments, the NCCIA can prosecute. So this entire machinery has been used. And there has been a lot of back and forth on jurisdiction and whether this can happen. And unfortunately, the High Court did hold that, these offenses could be tried together. So that's how all of this ended up with PICA specifically. Now, there have been long-standing concerns with respect to the FIA's role, even prior and separate from blasphemy cases, in terms of the way that these FIRs would be registered, cases would be investigated, the collusion of investigating officers, and especially the practices of search and seizure, where phones would be taken. And we've seen that in political cases, phones are taken. And while the law stipulates that the investigation agency must obtain a warrant, in 9 years of PICA, I have not seen a warrant obtained. It is always arrest the person, take their phone, get them to either unlock it or break into the phone. Now, there are huge concerns of chain of custody and evidentiary value as well, right? But the fact is that all of this coercive process happens, and then the technical report and the forensic report is also produced by them, or then a separate, so the initial report is in-house, and then you might have a forensic lab produce another. But again, that also has a huge question mark over it, because the investigating agency, and obviously has an interest in the prosecution, is doing this. It's not independent. And we've been asking for independent labs separate from the FIA or the NCCIA and the government. That has not happened in all of these years either. So there's that, and then the ability of courts to actually understand or identify if any tampering has taken place, and where do you look for it in a forensic report. And all of this matters because ultimately that's what you have to poke holes in, the case or the prosecution, and whether they have been able to identify that connection with the accused. And here we've seen, and I have been present in some of the cases that, for example, Hadi, when he was conducting the cross-examination. And the other thing I must mention with these cases is that courts were also not allowing the cross-examination to happen for a proper defense of the accused. And in some cases, there was one particular case where the file had been closed as though the cross had been conducted, whereas it evidently had not been, and the counsel had said the same. And Hadi can elaborate on that. So we've seen all of these things play out at the trial level, and I recall specifically that first cross-examination that did take place, and the kind of things that came out, and what the courtroom was a witness to. Hadi has already told you how intimidating the environment is in a trial court, but even in the High Court, we witnessed this in the commission hearings. And that's why the live streaming began, because there was an attempt to intimidate the judge by shouting, by filling the courtroom. But here, in a blasphemy trial, when the cross-examination is being conducted, and the complainant, who is a man, but on paper, his Facebook ID is of a woman. He's running an account in the name of a woman. And when he is asked, is this permissible? He says, yes, it's permissible. The other question that arises is that he was in that group where supposedly, and then close messenger group where this blasphemous content was being shared. So how is it that there was never a question about him being in that group? That never came up when he filed the complaint. There was never any confirmation, verification by the FIA. Why was this person? Does that, by virtue of him being in the same group, make him complicit? Although his defense was, well, I was sitting there to identify such individuals, but sitting there for years, which is what the record is. And then after that, the same account was also found surrendered. And these are the words that you find, and they have no basis in law, that these accounts are being surrendered to the FIA. The law has no basis for this. And then the same accounts are appearing in following FIRs as well. So if it had already been surrendered, then who has been operating these accounts? Was it somebody at the FIA who had access to a complainant's social media account or a device? And what does that say about evidentiary value again, and also about connecting the accused? So if, as Hadi mentioned, people were abducted, their phones were taken, material was planted, and this is one of the, and this again makes it a very precarious situation where how are you able to connect the accused to the crime that was committed, right? In certain instances, it has been found that, the person wasn't, had been kidnapped, or whether there was an FIR, not an FIR. And the fact that it is so coercive, I also met some of the families at the hearings and otherwise, separately, each of them, gave their version of account of what happened. And it was almost identical to the next families. And it's not as if anybody had a heads up to rehearse it, right? This is really the sequence of events that happened. And then the families were scared into not speaking about it. And this happened when they were first called to the FIA offices and told that this is what your son or your brother is involved in. And if you go out and tell anybody, then they can come burn down your houses. So they were also scared in a manner where they didn't confide in anybody until the numbers of these accused, young people who were accused, grew, and they started pointing out each other's families and said, go speak to them. This has happened to someone similar. So much so that there is a blind, he cannot see. Hadi met him. He's visually impaired. Yet he has been implicated in this case for electronic blasphemy. And so these are the things where obviously it's so one is this charge that is against them, the societal taboo and dilemma where they cannot go and share this. And then on top of it, you have, you're already condemned by virtue of this so-called process where they've spent a considerable amount in jail already. And so even now that you're getting acquitted, even if you're getting bail, but that also puts their lives in jeopardy, because those who find out, there's always a target on your back by virtue of the allegation against you. I spoke to some families who actually said, we've not disclosed what the case is about. We've actually told our neighbors or our family that it's a political case, because that somehow is a better thing to say than to say that this is what they've been implicated in. So these are obviously some of the connected issues. But the other thing that I have seen change is the conversation. And that has only happened because when the hearings were live streamed, or when some of these cross-examinations happened and there were lawyers sitting in who said that we didn't know, and I was privy to this, one lawyer after the cross-examination that Harry conducted came outside and he said, I really doubted what side you were on, what you were doing. But after I heard this, and I went and got the cross-examination, the whole record of it. And he said, I'm going to go and spread this because I have a 10-year-old son at home. Tomorrow, anything can happen. And so that sort of like trickle down sort of effect where people understanding that anybody can fall a victim to this. There were people, like they mentioned, who were offered jobs. So it wasn't even about being in a group where pornography was being shared, and that has some sort of social taboo attached to it. There were people who were looking for jobs who was told that I will send you to France, you transfer this, and they even transferred money to their accounts for travel, right? So it seemed legitimate. And that essentially, I mean, this is the way that they've cast the net, but the social conversation I saw shifted, where you could see that when the live stream happened and when all these contradictions were brought out, and there was no opportunity prior to that. And when this started happening in real time, and they saw both sides presenting their arguments, and the evidence was coming on record, that's when the social conversation shifted, because we saw that the families came together. 101 families came together to petition, which is no small thing as well. So that kind of solidarity, I guess, by default, just because of the scale of this and the nature of this, we've seen that that conversation has happened. Unfortunately, that order has been set aside due to what we have seen in the Pakistan judiciary with the 26 and now 27 amendments, where there's a complete capture of the judiciary and the few independent judges that were there, among whom was a judge who had ordered that a commission be formed, and that's been set aside. And the federal government, as Hadi already mentioned, has no inclination to do so. But irrespective, we are seeing that these cases are being pursued in the trial court. There has been conversation. And that conversation is happening within the courtrooms and outside and in other spaces on social media as well.
Great. Thank you very much, Farieha. You've actually touched upon a variety of issues, all of which are very important. Just by way of clarification for those who may not know, Hadi and Farieha also mentioned NCCIA, which is the National Cyber Crime Investigation Agency, which was apart from the FIA, which is the Federal Investigative Agency. I'm going to ask Hassan now to speak, but before that, Hadi, if you could briefly, since Farieha mentioned, say something about the problem of not being able to put up a proper defense for victims, which Farieha mentioned in passing. Would you like to say something briefly? And then we'll come to Hassan, or you can speak later if you want.
Sure. So what Farieha just mentioned is something that Farieha was inside the courtroom when it happened. And what happened is that when I was contacted by a certain accused who had asked me from the jail that I do not afford a lawyer, so I need a pro bono lawyer, so if you could represent me. And I agreed. So when I reached the trial court and I gave my power of attorney in the courtroom to represent this individual, I was told by the trial court that what you have to do is submit answers under section 342 of the Criminal Procedure Code, and then do your final arguments, and then we'll conclude this trial and give out a judgment. So giving out the answers to section 342 CRPC is the second last stage in the trial. So I inquired from the trial court whether the cross-examination on the prosecution witnesses has been done. And they told, yes, we've done that. And I said, well, this accused never had legal counsel in this trial. Who has done that? So they told, we arranged a state counsel, a defense counsel on state expense for him, who has done all of this. So when I checked the files out, the name mentioned was Advocate Nabila Irshad, who I personally knew. So I called the female lawyer inside the courtroom and I asked why have you done such a bad job in this trial while examining the prosecution witnesses. To my shock, she told me that she has not done this cross-examination. And I told the trial court that the lawyer you're mentioning has done cross-examination is refusing that she has ever done this. So who has done this cross-examination? You've written her name, you've written down the questions and answers. And the judge was also shocked that I don't know who's done this. And I lodged a formal application of the complaint against the trial court that how were you about to reach a conclusion of the trial, giving him death penalty, because the conviction rate in that trial court is 100%. They've never acquitted any person accused of blasphemy. After which the trial court allowed me to again re-cross-examine the witnesses, but that was an attempt to give a judgment on his trial without hearing him out. This was without any legal representation, and we've seen that in a lot of trials where the judge becomes a party with the gang, with the prosecution, and refuses to take notice of anything and is actually scared. After this, the trial judge actually called me into his chamber and he told me that this gang is really dangerous and I do not dare to question who has put that cross-examination, I do not question them on any irregularity or illegality they've done, because my own life is at risk.
Okay, thank you. Farieha, one point just by way of clarification, which is when you mentioned that, they put up these profiles and all, especially on Facebook, to enter these networks and groups. Do they use, as profile photographs, do they use photographs of actual other people, or are they like, AI generated images, or, some other image? Or do they not have any images, the profile?
Hadi would be able to respond to that better because he's seen a lot of the files, but the names are certainly of women.
Yeah, so what happens is most of these fake profiles have pictures of a female, the pictures of women, but we don't know who they are, and it's certainly not them because it's the actual person is a man. But they put on pictures, sometimes downloaded from Google or somewhere else. But there's no information on who these women are. There was one account who had a picture of a young child around 7, 8 years old. That was also not him. So we've asked these questions in cross-examination, that this is not your picture. This
Sure,
is
but
no one from your family.
but they're actual people, wherever the photographs may have come from. They're not like cartoons or anything.
No, they're actual humans. Yeah,
They're actual humans. Okay, great. Thank you. I'm sure we'll come back to a lot of these questions. It is now my very pleasant duty to invite Hassan Niazi, who has very kindly agreed to be discussant for this afternoon's event. Hassan is advocate in the High Court of Lahore, focusing on internet and technology laws, amongst various other things. Hassan, please speak now. You've been patient for a long time.
Thank you so much, and thank you everyone else. I must give, first of all, a lot of credit to people like Hadi, people like Iman Mazari, and all the other lawyers who have represented the accused in these cases, especially in a system which I want to talk about, where there is a lack of lawyers willing to come and defend people accused of blasphemy. And that is one of the biggest hurdles in the justice system when this gang is operating. They know that there will not be people who will be brave enough to come forward, defend these accused. They know that the FIA and the PTA, who is basically the chief content censor under PECA, will not push back against him. I can, for example, tell you that in certain roles, I have had the opportunity to interact with people in the FIA, people in the PTA, both institutions that have significant powers under PECA. And I have seen how they have given the same sort of moral defense of allegations of blasphemy. They have given blasphemy far more importance as an offense than any of the other offenses under PECA, because you have to remember, PECA, when it was initially conceived, was conceived to curb terrorist content online. It happened after the APS attack in 2014 and was framed as part of the National Action Plan that Pakistan framed. The other justification that was given, and Farieha and I have talked about this many times, is that it was supposed to protect women from harassment. Now, if you look at the trajectory of PECA over the last almost 10 years now, which is something I've been looking at for over the past few months, is that none of these things came to be true. It became a law that was actually used either to curb dissent or used by the powerful, those who have economic means, to suppress critical voices. Now, it was only a matter of time when this law would be weaponized by essentially an extortion racket, which is the Blasphemy Business Group. Now, PECA itself, because it's become so easy to lodge a complaint under PECA before the FIA, was a problem. Now, when you combine that with Pakistan's blasphemy law, for example, 295C and 295B, the problem sort of aggravates. And the reason for that is, if you look at 295C, there is no requirement for intent, malicious intent, or anything along those lines. In law, what we call mens rea. The act itself is the offense, whether you did it by accident, whether you did it not knowing what you were doing, whether you were mentally unwell, it does not matter. It was framed in that way. So it is essentially strict liability. Now, when you have a law like that, which uses words like defiling the name of so-and-so, a holy figure, that word itself is also not defined. So it is completely open. Anything possible, as creative as you can be, could possibly be blasphemy. These two laws combined, along with a law enforcement mechanism, which actually has shown sympathy for the blasphemy crusade, is essentially a recipe for disaster. And Hadi and Farieha and everyone has seen that firsthand. Now, when Hadi mentions in court the problems, I remember actually merely a few weeks ago, I was in the Islamabad High Court for my own case, and I saw Hadi arguing a bail matter for a blasphemy accused. And Hadi, I don't think we met that day, but I saw you arguing, and there was Hadi on one side and there was an entire gang on the other side. And so the intimidation factor against judges, even judges of the High Court, is very high. So you can imagine when it comes to lower court judges, who historically, they don't have that same level of, I would say, social, economic, or even other protections that sometimes High Court judges have, are very, very cautious about pushing back or asking hard questions about this sort of material. If we go back in time and look at some of the cases, there's a very famous case that people who want to understand blasphemy may want to read, and that is the Salamat Masih case. And the Salamat Masih case, the reason it's very important is as it combines all these societal elements into one big case. It is essentially about a 13-year-old Christian boy who was accused of blasphemy for scrawling, I think it was wall chalking, certain blasphemous material that he was accused of. And when they went into the case, it became very clear that one, this was essentially an accusation to settle a personal vendetta, like so many blasphemy cases are in Punjab. And despite knowing this, the investigation, the police, etc., barely ever push back when these allegations come forth. And I'll go into that a bit further, but in that case, even when it went to the High Court and the High Court lambasted the lower court's process, and there was an eventual acquittal, the thing about blasphemy and the thing about this group is that even when people are acquitted, it is a haunting harm. It follows you forever in Pakistan. So it will not matter to certain individuals if you have been acquitted. We saw that when the Supreme Court made a major decision acquitting women accused of blasphemy, and the Tehreek-e-Labbaik essentially started threatening Supreme Court judges, even though all they had done was say, this woman is innocent. So the Salamat Masih case would end with the accused having to flee to Germany. And furthermore, the High Court judge, when he retired, he was shot down in cold blood in his chambers. And till this date, it is assumed, although not proved, that it had to do with the decision he gave in that case. Now, when I say that lower courts are and law enforcement is very cautious about pushing back, if you look at some statistics, right, like under PECA, I mentioned the Pakistan Telecom Authority. Now, what the Pakistan Telecom Authority does is it reports content that is unlawful to social media companies on the internet. It basically acts as a censor and a content moderator. If you look at some of the statistics, one of the highest volume reporters of online content in the world for some of the social media companies was the PTA. Why is that? They are far bigger countries than ours with far bigger populations. And most of the content was blasphemy. And when you dig into that and try to question why, it's because they did not want to push back on any of the requests that were coming their way. Nobody wanted to say, this is not blasphemy. Nobody wanted to take it on their shoulders. So they were just churning it all forward to social media companies. And so that they will take the decision. And then we will be able to say that, oh, look, they didn't do something. It's not our fault. We did everything we could. Similarly, with the FIA, I think even those who are not complicit with the blasphemy business group, it has become so difficult to just simply push back and say something is not blasphemy. And essentially, because the law is so broad, vague, and open, as I have said, it has become a huge problem. Now, the thing that Farieha mentioned in these cases is there is a problem with regards to evidence. A lot of these cases are being done through social media platforms, maybe WhatsApp, maybe Facebook Messenger, and so on. The government is not interested in creating some sort of protocols with social media companies through which an actual defense can be mounted. Hadi and others are unable to get certain information that even judges sometimes ask for. That can we get information about when this profile was created? Was this profile ever hacked? Who put this content here and when? And while the government has a mechanism with these companies where they can get data that they can use against an accused, there is nothing in reverse that anyone can use. And that is something that unfortunately I do not see the government taking up. But we as activists, civil society and human rights activists, must raise this with social media platforms as well to try and find a way through which we can gather this sort of important evidence so that these innocent people can be given the best defense they deserve.
Great, thank you. Before we proceed, and Afiya, I'm going to ask you to come back and say anything that you would like to, but before that, because Hassan referred in the context of the introduction of the Pakistan Electronic Cyber Act, the very unfortunate incident of the attack on Army Public School in Peshawar is what Hassan was referring to those of you who may not know. It happened in December of 2014. There were 6 foreign terrorists involved. 149 people were killed, of which more than 130, I think 132 were children. A lot of people were also saved from that situation when the Special Services Group intervened once they got to know. But I mention it in some detail because the terrorist attacks and the killing of innocent people is unforgivable at any point in time. But the killing of children who have gone to school to study must count amongst unforgivable crimes of the highest order. And I think that at every point we must acknowledge that openly. Afiya.
Thank you. Just to pick up on a couple of points that all three have mentioned, I do want to caution, and I said this before, on this idea that these cases are almost always profane in a way, and that they are always about personal vendetta. That's actually not completely accurate. They have been for a large part, but increasingly we see accusers claiming genuine offense. For example, the case about naming a perfume 295C and launching it. The Tehreek-e-Labbaik representative who filed that complaint said that I'm upset because I see it as a criticism or a trivializing of the. So the law itself has become sacred, and as Hassan says that it's undefined, it's broad enough to do this, and often there's no skin in the game for the accuser themselves, particularly when it's about policing women and the gender nature of it. So what she's wearing, there's no personal vendetta in it, but it's driven by a certain misogyny or patriarchy or a moral policing that's going on. And that, I think, is something that we need to be caught, because for too long, as activists, we have dismissed this idea that we're always looking for the kind of capitalist motive, the vendetta, the class aspect of it, and it's actually spilled beyond that. The second thing, Hadi mentioned as well, and Farieha, that, for us, by the time we got around to finding this case out itself, it's incredible. It's an informal network of activists of somebody who's in the human rights ministry, who knows me, who says, please go and interview these women in jail or find out what's happening with them. It's an absolutely accidental relief that many of these the victims get in this case. And that's not a sustainable way to deal with these cases. This is not going to be the last. The law is not going to be reformed anytime soon. And I think one other point that's important is the tipping point for this particular case. Not just that accidentally we've found a lawyer who who was willing to do it pro bono. We found a journalist who exposed it. But the tipping point really was two things. That one, as Farieha mentioned, they started live streaming the court case itself. That reached a certain expanse. The second is that certain journalists who were courageous enough, and also outside the country, to publish exposés around it. Otherwise, you don't get sympathetic journalists. Forget the judges. That also is a big factor. And the third point was that none, apart from the fact that Hadi found that there's no prosecution or the accused didn't have a defense, but also that the courts were unwilling to perform forensics on the phones that were said to be evidence in themselves. So Hadi had to argue, and the other lawyers had to argue for forensics to be done, which is also going to be done by a state authority. And so the tipping point one was that live streaming. The second was, as Farieha mentioned, the mothers and sisters of the victims coming together on a platform. That was critical because there's complete silence. There, you need a lot of courage to come out and talk about, the blasphemy. Just forget criticizing the law. Just to even become a victim, to talk about your victimization, takes a lot of courage and guts. You don't think you're going to get support from the neighbors. You're not going to get it from the state, certainly. So, these are clearly the blasphemy lawfare has turned into a form of carceral theology. And it is self-sustained because clerical populism, as I said, state complicity, and the state, prior, the state used to be the one who was instituting these cases or the one who was using it as a tool of persecution. Today, the state is quite willing to be a benign beneficiary, a neutral beneficiary. It's not going to change the law. It doesn't institute the cases. But I think that we cannot underestimate the kind of, and also, Nilanjan, just to mention that there's also a split in civil society on how to deal with this. There was one set that was clearly, historically, and generationally arguing for the repeal of the blasphemy laws, and another set, particularly in the post 9/11 period, when the concept of piety becomes more benign, becomes something that is more romanticized and is considered to be neutral and benign, etc., that where they feel that there should be more of a revivalist looking for doctrinal authenticity versus inauthenticity. So we're kind of trapped at every list, not just the state. I think we also have to take responsibility to say how we have not come up with a solution or abdicated one set of arguments over the other. And of course, the state and the courts will continue to be suspended in their positions on this or stick hard to these positions because there's no pressure on them to do anything otherwise.
Thank you. If I could just announce for those who are watching online that if you would like to ask any questions, please do by using the chat box function. Now, just the issues that Afiya has just raised, we'll just go around and ask. But I wanted to also ask a few questions that were very basic, and then we can, all have a conversation about this. One of the things is when Hadi, you started speaking, you mentioned the whole question of, economic benefit that is involved in accusations. This is not new to the world of crimes and is definitely not new to the subcontinent. If you look back into historical records, archival records from colonial times across the subcontinent, across the landmass of South Asia, you will see, for instance, that in several rural areas, when a woman lost her husband, became a widow, and inherited property, members of the family would get together and accuse her of being a witch. And, the whole thing of witchcraft in that sense, and the accusations of witchcraft, and this is going back to the 19th century. So what I'm trying to say is there is a framework within which there's almost an organic framework within which these sorts of accusations happen. But there is also another very important thing I wanted to mention, which actually goes back to something that Farieha said, is that what about the people who actually become part of these networks? in order to do this. Now, impersonation has been a tactic amongst police forces in various parts of the world too. And even now, for instance, you will see people entering gangs of hackers through impersonation, or the sting operations that journalists do, and so on and so forth. So impersonation is it is a crime, but it is a crime that seems to be known to many people and put to a variety of users. What I was interested to hear from both from Hadi and from Farieha, but also Hassan, if you have to add anything to it, is the people who are involved in this, because Afiya used the word business, Hadi, you used the word gang. The people who are involved in these, they're sort of, as they come across in what you're saying, they're like self-appointed vigilantes, right? But what is their day job? Like, who are they? Do you see what I'm saying? Do you have any information? Like, I mean, literally, who are they?
Yeah. So sorry, Faria, if I can just, I'll just add into what you've said is that it's been a tactic by law enforcement to blend into, or go undercover within the ranks of a certain network to catch certain individuals who they suspect of committing crimes. But I think there's a very clear line that you draw. So, for example, what these individuals have done, it would have been a very different thing if they would have gone into certain online groups on certain social media platforms. And what they would have done from there is they would have observed criminal activity. They would have observed objectionable content that would fall within the ambit of a certain crime or a certain crime's ingredients in Pakistani law. And they would have returned back and reported that to law enforcement. But that's not what happened with the Blasphemy business gang. What has happened here is there's very clear evidence of conversations, there's very clear evidence of objectionable material that would fall within the whatever definition we have right now in Pakistan, no matter how unfair that is, but within that, and there's evidence of that of content being sent by the gang members. There's evidence of these gang members being a member of a certain group for the last few years. And we've seen through documents, that these people were not even on social media for the last those years. So what they've done is they've actually, what I suspect, and I, to be honest, don't have evidence of that right now, but this is what victims who have gotten bailed out from jail have told us, is that these people have bought these social media accounts, which are sometimes, in fact, blasphemous accounts. They've bought these accounts by paying for them, and then they've planted them on innocent victims. They've planted them on these people, and then they've handed them over to FIA. The same FIA or NCCIA that is complacent in this, that takes a certain part of the extortion bill. And when you've asked what they do in their real life, so people who have been using this as a mode of extorting money from these individuals, they don't do anything. They don't have, what's interesting is they do not have a clear source of income or documents of tax returns in Pakistan that would show or prove or justify their living standard. So what they've not been able to do is explain how they've made so much wealth. And it's clear that they've done because of this. They've made a huge amount of money from by extorting money from these victims. And that's very clear to us.
So are you saying, this is just for clarity, are you saying they extort money, they take money, and then hand over the victim to the agency, or they let the victim go once the victim has paid money?
There's a distinction between the two classes of people. So what you'll see is that out of these 750 individuals, you will find that all of these 750 individuals belong to the lowest class of the society. They're really low class. They're like at the bottom of the social
You
circle.
mean
They make economically, yes, economically they make really minimum wages. They mostly are daily wage workers, and that is why they've all been incriminated, because people who could pay their way out of this were never prosecuted. And I've personally met three families who've told me that we were asked to give 10 million rupees, and we had to raise 10 million, and we've given that to the gang. We will not say this publicly, because if we say that publicly, we'll be accepting two things. One, that our loved one, our son or our brother, was accused of blasphemy, and secondly, that we've bribed our way out of it by giving extortion money to the gang. But they've told us, which is why none of the victims belongs to a higher economic class in the society. All of these individuals are really minimum wage workers. But even these, just to add, even these minimum wage workers have given around, there's an average of 1 million to 2 million rupees. They've given that just to not being tortured every day. While they're in physical remand, they pay these sums not to be tortured and sent to jail and then prosecuted.
That's very interesting, because also the other thing, if you're in a position to sort of garner 10 million or 20 million or whatever is asked and pay it, again, and talking about the social context of how society works, is there is built into payment an admission of guilt, that they must have done something wrong for the families to agree to pay and therefore to buy them out. And there's always that shadow all the time, just as there is, as Hadi just said, the whole question of admitting to the fact that you've bribed and therefore corrupted the system, or played into the corruption. Farieha.
Just very quickly, if I may add, Nilanjan, that the profile of some of these complainants. One of them, for example, and Hadi mentioned the lack of tax returns, and I recall that during a cross-examination, he said he runs a car workshop, right? That's sort of the profile of the complainant's so-called day job, but then this self-anointed vigilante, as you rightly put, and that's what they've been doing, and serving. And there's an entire nexus, because then there's some of them are lawyers, some of them are connected to the clergy, some of them are just random individuals who are then becoming complainants in multiple FIRs. The lawyers are also complainants, these people running workshops are also complainants, etc. And whereas when you ask them, hold them to account, do you pay taxes? Do you have a record of what you do? What is your motivation? There aren't any credible answers, right? But just because of how this network works, they also in terms of, the extortion, where the families themselves said they were asked, and, these are, as Hadi mentioned, they're working class families, right, from all over Pakistan. And many of them are incredibly poor. These are, I think the profile of these, a lot of the young men between 18 to 35, educated also fairly, but, or some university going, some looking for jobs, etc. And one of them I recall, who, as we say, there's the dressmaker. Now, if you're asking even them, who are living in privileged areas, they start with 1 crore. And when they do scramble to get money, I know one family said that we still tried to put money together, and they were able to come up with a few lakhs, right? Which wasn't anything near the figure. But the fact that even to collect a few lakhs is well beyond their means. And there is this desperation to just be able to save their relatives' life, because there are people who have also lost their lives to torture. And there was one case that came up of one who was murdered after the abduction, or who could not sustain the torture, which ultimately it seems led to the murder.
Thanks. There are several other related issues, obviously, to this, and I'm conscious of time. But before I say anything further, Hassan, did you want to come in and say anything?
I think fundamentally, when we're talking about how these people are desperately collecting money, and what a big burden that is, I mean, there's two factors that we cannot ignore, right? One is the stigma associated with a blasphemy allegation, even if you are acquitted. The second thing is far deeper. There is a lack of trust in the justice system. People do not trust the judges, they do not trust the FIA, and they do not believe they will get a fair trial. So they believe that the only way to escape these problems is then to either accept the demands, cough up the money somehow and just get out of it. Otherwise, the Kafkaesque justice system, as we have just explained, where judges, prosecutors, law enforcement, everyone in some way has also that moral crusader within them that sympathizes with the blasphemy cause. And you have to understand, the state has also caused this, because a while back, you would have the telecom authority, the PTA, openly asking people that please report blasphemous content to us. If you see blasphemous content, report it to us. And there were people who would sit down on their computers. You are asking, what are these people's day jobs? Some of them would just sit down and do this just for the sake of doing this. And it is like a crusade. And all of these crowdsourced content would then be sent to the PTA. And the PTA would then send it to the FIA. And this is how the entire process is self-perpetuating at the moment. So the state itself has been complicit. It had the opportunity. When Hadi filed the High Court petition, it was live streamed. People saw something. One, I believe, and this is my personal opinion, there might be disagreement, but I believe that in the legal community to which I belong to, people saw that we can stand up to these people. We can ask questions and we can defend people accused of blasphemy. And, these people perhaps are not as scary as we once thought. And a lot of credit goes to the live streaming process of crossing that sort of, I said it's like crossing the Rubicon in some ways. But when it all came back to a lack of trust in the justice system, because as soon as that order came, that the state should form a commission to independently examine the veracity of the claims that Hadi and others had raised about a blasphemy business group. The next day, the order is suspended by a division bench of the High Court. And Hadi, I don't know if that case has ever been taken up after that, but I feel like it's essentially gone then. And this is why we need independent judges. And it is also why we need an independent media that is free of PECA. Because if it had not been for Fact Focus and other media outlets that actually reported on this, people would not know. And these stories would go unheard. So it's a broader issue we must discuss, not just the blasphemy law, PECA itself, and the state's role in enabling this sort of lawfare.
I'm going to, Hadi, we're just going to come to you, but I think one of the points that no one has mentioned till now and would be important to clarify and mention, especially for the benefit of members of the audience, is that these accusations of blasphemy are not against minority communities only. I think that's an important thing to mention. Am I correct in thinking that it applies to Muslims, to Sunnis, Shias, to all, all shades of Muslims? So it's there. I'm going to come to Hadi, but there's something I wanted to ask as well as clarify, and give Hassan the opportunity to clarify, is that you did say at the beginning, when you were making your earlier set of comments, that the law itself is actually so open-ended, and I noticed that you used the word vague, that the law is vague. You just said that there is also the unconscious moral imperative that individual judges and lawyers and all carry. So, and that perhaps comes into play. But one would imagine and presume that in a court of law, the litmus test for being guilty or innocent would be the imperatives that the law brings to bear, rather than one's personal sort of but since you said that the law itself is also very sort of open-ended and vague, has there been any conversation, has there been any talk about how the laws could be made more clear so that its applicability became easier for those who are sitting in adjudication? Hassan?
I think the question of reform is also made very cautiously. There have been a lot of demands for reform, there's no doubt about it. But you have to understand the level of caution that goes into even these demands. We must remember that a member of the government, Salman Taseer, was assassinated simply for criticizing the law itself. Um, Now, in terms of reforms, yes, one of the biggest reforms and probably one of the simplest reforms could be that this law needs to have at least some element of a mens rea requirement, that someone be doing this either for malicious intent or to incite violence. That is what even the colonial origin law of 295A understood, that you had to have intention and there had to be some link with violence. So it was more along the lines of an incitement of violence provision in a heterogeneous society. Now, all this talk of reform, there was one time there was talk of reform that if there was a false accusation of blasphemy, the person making the false accusation should be punished. So there have been conversations, but there is just not that lack of incentive from the government, because as I believe it was Hadi who mentioned, and Dr. Zia also mentioned, that the government is banking on these votes. They do not want to antagonize this vote bank, and there is no political capital that they want to expend on this issue. Because the people, like Hadi said, that are suffering are unfortunately not from that class that has a lot of say in lawmaking in Pakistan, unfortunately, right? So in terms of judges, I would say that there have been cases, if you look at the case law, where sometimes judges have tried to read in an intent requirement into the law, but this really depends on the judge in a certain case. I have also seen judges, because there has been a time where Pakistan's judiciary has had very populist tendencies, and a former Chief Justice of the Lahore High Court had a petition before him where people said that the PTA is not taking down enough blasphemous content. And you could see he was making statements for the media that would come in to watch the case, saying that, I don't care, you will shut down all of social media if you have to, if you need to take this down. Funnily enough, he once said that, I don't understand, you can block roads, but you can't block social media. So there was this element of performance in that entire judgment. So it has really boiled down to a judge's personality. And of course, that is not how law should operate. So calls for reform are there, but there is no political will. And maybe Dr. Zia can maybe answer that question a bit better because of just the academic interest she has.
Afiya, we'll just come to you. You should let Hadi speak first. Yeah. Hadi, just to the things that Hassan was talking about.
Yeah, so I agree with Hassan. And I think if we're talking about the same judge, if it's Chaudhry Abdul Aziz, so I would just like to add Chaudhry Abdul Aziz was a blasphemy law activist himself before he became a judge of the Lahore High Court. He had been prosecuting these cases, whether it's Ribsha Masih or others. He's been prosecuting them, and he's been a strong advocate of the, I'd say, unfair use of the blasphemy laws. And when he became a judge, the role he played was so shameful. And it's very clear that he was one of his students, is Rao Abdur Rahim. He's from his chambers, and he fixed his student's case in his court and gave him relief in those cases. That does not make sense. And he also, through a case, through one of his judgment, established ABC in FIA and NCCIA. ABC's anti-blasphemy cell. So he made exclusive specific cells that would prosecute these cases. And then these cells later on went on to falsely incriminate these 750 individuals. He had to resign because of the social pressure. And according to my reports, a reference being filed against him, where he had unfairly, illegally fixed cases of his students in his court and unfairly given him relief. What Hassan also asked about the order of the Islamabad High Court to form an independent commission to inquire into these allegations. It was suspended by an ICA by the two judges who were brought in through the 26th Amendment, through a compromise that they made with the sitting government to give in judgments under the pressure of the government or a certain group or a gang, and that's exactly what they did. The case has been fixed 3 or 4 times after that, and all of those times it's been cancelled right before the hearing. They do not want to hear us. They've suspended the order without hearing us, this side of the lawyers. And every time they fix it now, they cancel it right before the morning of the hearing.
Afiya, reform and political will.
So this is a genuine challenge, really. I mean, you have an Islamic law, the zina law, which after 35 years of the women's movement campaigning against that discriminatory application of that, the adultery law, gets reformed, procedurally at least. But the blasphemy law is like really the last moral frontier for the clerical classes. They are not going to give up on this anytime soon. And the complication is not just the stigma that is attached when you become an accused, it's also that there is this, how do you accommodate genuine injury that the Muslim suffers, you know? So we mentioned the parties, the ruling parties who are unwilling to do so, but the liberal parties, they're not willing to do so either. And even Imran Khan has been on record saying that these laws are good because they provide a safety valve against vigilantism. And that didn't age very well at all, right, with this case. But what I'm saying is that there's no sector that is invested in this kind of reform, precisely because if you believe in the pious cause, how are you going to say that there should be something that outlaws, blasphemy in that sense? Now, so what we all agree on pretty much, the kind of minimum agreement is that, well, at least let's reform the procedure so that it's not used with sort of a willful abandon in that sense. There's also a revivalist proposal, which is really interesting. And this is the debate that takes place in civil society, where you have what are now sort of really, I mean, even Hadi has a campaign going on against him online by YouTube piety peddlers who have made it their cause to take down the liberal secular defenders of the blasphemy case or against blasphemy laws. So there's that momentum that builds up at the same time. So against that, there's this kind of a revivalist proposal that says reform suggestions, proposals. That one is to declare the blasphemy laws as a colonial biddat or innovation, according to Islamic history, right? And or to grant minorities protected dhimmi status, which is also a precedent in Islamic history, and I suppose with implied jizya tax, so that minorities get some kind of immunity from blasphemy allegations. The problem is that human rights and feminist groups reject both these suggestions because, one, it reinforces Sunni majoritarian authority, which is precisely where this blasphemy allegations come from. Biddat is a very Sunni concept. And secondly, it institutionalizes unequal citizenship and it reinforces the kind of casteism that Faisal Devji has argued informs blasphemy accusations, particularly against Christians. There's this concept of purifying Pakistan, purifying society by ridding the pollutants, the potential blasphemies. And so it traps us inside this debate over doctrinal authenticity versus inauthenticity rather than some universal rights, right? We don't even get into free speech and expression and freedom of expression, etc. And also, as Hassan mentioned, that, okay, even if we resolve all of these, the question you were asking about morality over law over morality, the point is that the law, unless you change it, that's still not going to alter enforcement. The courts are going to apply the clauses. Police will register FIRs. Digital vigilantes will still act. So you can make an enabling environment, but that unless you take care of the law and either introduce clarifications, tighten it up, make mens rea part of it, or repeal it, it's going to be really difficult. And we're just going to go case to case, and the momentum is going to build up. And like I said, it's going to be carceral theology for a very long time.
Thank you. You did take away one important word that I was going to use to bring the conversation perhaps to a close. We have about 5 minutes more, but we'll come to that later. I did want to ask Farieha if you had something to say or wanted to say more, since you are involved in that sector, about Hassan's point that civil society needs to do more.
Absolutely. Now, again, I mean, civil society for its role in the conversation, or a lot of what Afiya has mentioned, engagement with political parties, and of course, there's a divide there too. And that is one of the challenges, right? Because there's one section that says that if the law sort of acts as this defense, otherwise there would just be vigilantism and there would be just mob lynchings and murders, right? And we've seen that. And a lot of times we also hear from those who instrumentalize the law as saying that, well, at least we're taking it through the legal, the legal, but the thing is that how legal really is, and what Hadi has presented as well, right, is the entire process itself. That too is in question. And I think what does need to happen, what Hassan mentioned, and I think it is vital now because this is all about digital blasphemy or evidence and, offense, is the role of social media companies and how they're approaching it, and sort of to build that kind of a narrative where we're always concerned about what social media companies tend to share with authorities when they get requests for user data or other kinds of information, right? And we understand that, sure, there are certain lawful needs, but when you see that there's complicity within a law enforcement institution, what are they really sending bona fide requests for user data for criminal prosecution, or is it for other covert means? And then how is it that somebody accused can use it for their defense to evidence that whether their profile or account was actually hacked or in their possession, because these are things that very clearly show up on the back end, right? Which browser, which city, what your login history, etc. is, but none of that is actually available to you, nor is it something that you're able to use in the defense. And I think this is something that needs to be done a lot of. There are constraints, and has been mentioned in this conversation, a lot of the reporting happened from media based outside of Pakistan, just because of how difficult it is to report, and really until it was the live stream and that those were court proceedings. Otherwise, you would not see conversation on this, and the mainstream media is not talking about this as much, right? People are very cautious in terms of what they would say. To today even discuss, let's say, repeal or reform of the law itself. And I also want to mention that the blasphemy law is one, or the offenses religion. But then PICA also is an equally vague law and an instrument that is now used in tandem. And we've actually just had regressive reform with where PICA is concerned, because we've had even more vague offenses created as a result of an amendment that was made this year. And the procedural protections that existed prior to it have also been weakened, right? And so anybody can be a complainant who feels an offense has been committed under the law. And that really, really opens up the door for anybody and everybody. Things that we were able to challenge in a court of law in terms of the standing of the complainant, etc., all has been legalized, so to speak. And that's the specific challenge. At the moment, political parties, there's no will to engage. In the past, where certain political party members or parties have tried to table procedural reforms, they too have come under attack and have had to withdraw. And that, unfortunately, is the present environment. Nobody's going to stick their necks out, even with judges and where social media websites are concerned. Whole websites have been blocked, and even saying that don't block an entire website, you really had to, for example, YouTube was blocked on account of blasphemous content for 3 years in Pakistan, 2012 onwards. And the hearings that used to take place around that also, it was very carefully navigated, also because of the environment and what you could say and how much you would say. And so even with these present cases, it was the High Court did clarify that we are not talking about the law. The only question before the High Court, and the High Court said, was whether a commission should be formed to investigate the pattern that has emerged, and stayed very far away from the actual question of the law. And that then provided the space. Similarly, with the social media bit, with YouTube, it was the whole of YouTube is blocked. How can we make sure that certain content, if objectionable, there's provision to block it, but the entire website is not blocked? And that's how the conversation started. And that's essentially how you have to approach it, whether civil society, judges, politicians. So the space is very, very narrow here.
Thank you. We must end. We have come to the end of our time, but there is an elephant in the room that Afiya mentioned only in passing, and I was going to mention that and then give all of you the opportunity to give very brief answers by way of closing statements. But before I say that, I think it's important that we say that, one, blasphemy laws don't exist only in Pakistan, they exist in a lot of countries. Just as there are laws about hurting religious sentiments of communities that exist in countries where there are no blasphemy laws, etc., etc. So it's not something that sort of is singular to Pakistan. And the other caveat I think I want to mention before I pose my question is that we're all aware that rights come with duties and freedoms come with responsibilities. These are not absolute habitations for citizens. You can't have only rights and you can't have only freedoms. But having said this, there is the elephant in the room, and that elephant is freedom of speech. Is in the context of what we've been talking about, where is freedom of speech over here for the citizens of the country? And is it that one set of laws, in this instance blasphemy, because that's what we're talking about this afternoon, can completely overrule something like freedom of speech? Bearing in mind, as I said, that freedoms come with responsibilities. You can't just say what you want to say, etc. Because what we have discussed and heard this afternoon is that there are several instances where actually no definite or clear crime has been committed, but that it's a system that has worked itself into it. And Farieha mentioned that over a period of time a pattern has emerged where things are seen in a certain sense. So Hadi, shall we start with you? Freedom of speech and rights, duties, responsibilities.
I agree with you, but I'll just add into what you've said, is that, to be honest, in a broader spectrum, if we look at this, if the government of, for example, Pakistan, we're talking about Pakistan right now, the state of Pakistan is in a practice of misusing laws, it's not just PECA that they're misusing. For example, the ATA is also being misused. The 780A, the implication of making a certain incident or a certain crime fall within the definition of terrorism, that has been the modus operandi of this state. So if the state is in a practice of using or misusing these laws into curbing on voices of dissent or human rights activists or political parties or anyone they don't like being in free space and want to put them in jail, they lose the moral authority to then come up and save their citizens from a gang that has arisen and is prosecuting people in false cases of blasphemy. It is very difficult. And what they've done by using or misusing the law of terrorism or other draconian, tyrannical laws into curbing on voices of dissent, what they've done is they've destroyed the legal system. What we've done in this country through the 26th Amendment and 27th Amendment, just to make a certain powerful person in this country happy and all powerful, all controlling, is what we've done is we've kicked out all of the judges who could have performed, who could have impartially and taken a brave stand and done something for citizens of this country. So they've taken them out, they've brought in puppet judges in this legal system. So now the system is not even able to, it's not even able to come up and give out judgments or hear cases by giving relief to people who have been falsely convicted of blasphemy. That's what happened in this country. And what you've said earlier, I wanted to clarify that. So, in terms of Muslims and non-Muslims being victim of this, what we've seen with the gang is that 99% of the 750 victims are Muslims. There's some people who are even Hafiz Quran. There's a bail I have tomorrow morning fixed in the Islamabad High Court. The victim is a Hafiz Quran, and he's falsely accused of blasphemy.
Thank you. Hassan?
Look, I think I agree with something Hadi has said, right? Like, freedom of expression is very dependent on the state itself and its institutions, right? And how much they believe in it. And then there is the judiciary and how it enforces it. Now, from what I have seen, having worked in the space of online content and freedom of expression over the last few years, is that the appeals to Article 19, which is freedom of speech in the Constitution of Pakistan, appeals to the ICCPR, which Pakistan is a signatory to and has ratified, fall on deaf ears, frankly. There are judgments of the Supreme Court that talk about when freedom of speech is to be restricted. There are judgments that talk about when the FIA can act against someone for online content and what due process requirements must be followed. And what happens is both the FIA and the PTA completely ignore these precedents, and there is no accountability for it. So essentially, what we have created is a system where it is now normalized to break the law, essentially, to achieve certain ends that the state wants. And right now we have a state that I would say very frankly, and I would say this about the previous government as well, is that they have not been champions of freedom of speech, right? And we have had some judges who have tried to push back, but they have been few and far between. If you look at the doctrinal development, there's no clear doctrine on even blasphemy cases and freedom of speech in terms of precedent. So I think even if we were to build in fail-safes into these laws, like you asked before, the fact of the matter is, if you have this executive, members of the legislature, and so on, who, sorry to say, are just going to use the law in bad faith, then no law is going to be, even the best protections of free speech that you put into the Constitution are not going to be effective. So this is why it is not just a legal battle, it is essentially a battle for democracy itself in Pakistan that requires a cultural and societal change. And so it's quite the battle that we're facing in terms of freedom of speech, which goes much beyond blasphemy. It goes much further, like Hadi has said. And that is what we are committed towards, working towards. And we will continue, raising the voice for this, for an independent judiciary and independent media, and for freedom of speech.
Yes, I think that was the reason why I wanted to raise it at the very end, is that actually the whole freedom of speech question far exceeds something as specific as blasphemy, howsoever vaguely articulated or defined in law, or the hurting of religious sentiments, or the will of the mob, if you will, or of vigilantes, because there is a much bigger place and a dynamism that freedom of speech has in relation to democracy. I think that was the reason I raised it. And also, some of you, I think Hassan, you, and definitely Hadi, you have mentioned the 27th Amendment, which is worthy of a separate conversation in and of itself. But again, in the context of democracy, is one of the more interesting features of the 27th Amendment is the creation of types of citizens, that there are citizens to whom law will apply in different degrees, and so whereas a modern nation and a modern democracy, at least in the eyes of law, all citizens must be equal, because there is inequality in every other aspect of existence, whether it's social or educational or whatever. Farieha, did you want to say something about freedom of speech?
It's very quickly what else. Especially when it comes to blasphemy, and often the way that we frame it, is always outside of the freedom of expression. And oftentimes, and even when there is litigation around certain issues, I think due process always takes more precedence just because of how coercive the process tends to be, or excessive or overbroad, whether it's incriminating somebody through a first information report or having a website blocked, right? It is always an elephant-footed approach that is taken. And so a lot of the arguments are, and it's not just about something as contentious as this, even if, let's say, it's a sedition charge, we never really get to the seditious so-called speech, but it's everything that happens prior to that. And unfortunately, that's why we haven't seen jurisprudence develop. So we have an Article 19 in the Constitution, which gives us the freedom of speech, but it's subject to a lot of limitations, right? And all of those categories are incredibly vague. And we haven't had Parliament legislate on Article 19, unlike how we've seen Article 19A, which is, access to information. And then the judiciary also in applying what should be protections, we don't have that kind of jurisprudence for freedom of expression. And the public narrative is usually, well, should they have said this? Should they have, and it's always comes from that point of view, or it's like you mentioned, that freedom of expression is not unlimited, right? There are exceptions, but those exceptions must also be reasonably applied, which we don't happen. And we typically get caught up in was it a reasonable application, whether by enacting a statute, whether by, judicially pronouncing something, etc., or executive action. And that, I feel, has been our freedom of expression space, essentially, where in the legal space, that's where we've been caught up.
Great. Afiya, you have the last word.
So I think the question of freedom of expression or speech is not the elephant in the room. It's really taken over the whole house, as everyone has mentioned. There is no freedom to criticize or be critical about either the military or religion. One is taken to undermine national security. The other one is blasphemy. It's quite simple in that sense and reductive. The one other space to watch really, Nilanjan, is this intra-clerical debate that Hadi mentioned, because recently we've been seeing a lot of cases of that as well, where people are, clerics who are sort of, are very popular as well. They are also part of the populism wave. Even one of them is also sort of been accused of blasphemy, is in jail right now, undergoing the case. But I think the point of this discussion was really just to highlight or to expand the idea that it's a kind of been a lazy analysis on the part of activists, where we tend to look at the blasphemy laws, the challenge, as simply a colonial legacy or just some bad faith actors at work, and the refusal to see the systemic connectivity that defines now the moral economies of blasphemy. And the idea was to discuss this case for its own for its own interest, for the fact that, and I do want to point out and appreciate that this is a different generation. Hadi's and, Farieha's, etc., is a different generation that is not enamored by or apologetic about how they're approaching the issue. For them, it's injustice. And they see everything. They're not worried too much about the baggage of it. They're interested and invested in a sort of constitutional debate and a constitutional struggle, and not in a theological one or in a sort of an anthropological exercise of it. And that's why I think that is hopeful for me. That's a space of hope, where their courage and the few that come together, they've taken on the state in this regard. And that's not an easy task by any means.
Thank you. Thank you very much. I'm afraid we must end. This has been a very, very interesting discussion. And thank you, everyone. For those of you who are watching online and have watched any of our events, I always say that if there's anything good that came out of COVID, it is that we became technologically savvy. And we all learned how to use Zoom. So we were able to convene these fantastic discussions, across space in the same time. And that is a privilege for us. It is a privilege for our listeners to hear so many views from so many of you. But I also say always that we can't do this if each of you and all of you together do not give so freely of your time and your expertise. So thank you very much to each each of you, to Afiya Zia, to Farieha Aziz, to Hadi Ali Chattha, and to Hassan.